Hello everybody, welcome in Uruguay, in the Netherlands, for this match. My name is Aurélien Lorange. I'm organizing this match. I'm host on the side of the Coax Foundation between two teams who qualified from the group phase in the Hague Inter-University Law Debate Tournament 2023, 6th edition, and this is one of the matches of the 8th of finals. So we have today two teams. Two teams will be debating on a topic they received 7 days ago, which is about international law, and they will know only today which position they will be defending concerning this motion. So before, of course, jumping into this match, we'll give the floor to the actors of this match, so it means the students themselves, for introducing themselves for the audience. So I would like to give the floor first to Mr. Michelini, Ignacio Michelini in Uruguay.
Well, hi to everyone. Well, good morning here in Uruguay. I don't know which time is there in The Hague, but my name is Ignacio Michelini. I'm a fourth-year student of law school here in University of the Republic in Montevideo.
Welcome, thank you very much. We have as well Mr. Tolga Dugan in The Hague.
Good afternoon. It currently is 2 p.m. here in The Hague. My name is Tolga Dogan. I'm 20 years old, from Germany, and a second-year international European law student here at The Hague University.
Welcome, thank you very much. We have as well Miss Maria Federica Sanz.
Hi, good morning. I'm in third year of law school.
Yes, welcome. We have as well Mr. Simon Cookval. Sorry.
Thank you, and good morning, good afternoon. I'm also second year here at the Hague University.
Welcome, and thank you for joining at this time. So both teams, they had to prepare a topic, as I said a bit earlier. The topic is, in the absence of international legislation on space resource extraction, customary international law should be guided by the national legal framework of states that have an established legal framework for such an activity. To be aware as well, yes, of course I work at the university, it's a fact, but I'm not judging anything in the competition. I'm just hosting this match and some others. The three judges for this match are from Zambia, from Armenia, and from Feroe Islands. They might watch maybe the match on YouTube, or let's say during the next hours, and they will be assessing the two teams during this match. So this is a qualifying match for the quarter-finals, which will take place in 2 weeks. So now I will share my screen for the allocation of the positions live. So students in the room will be able to see which position they will have to defend during this session. So as you may see in a few seconds, I have one judge who is joining. So as you may see in this screen, there are two possibilities for the two universities, either to be in favor, either to be against, for the University of Applied Science, or for the University of the Republic. So we click in the center, and they will know, and we will all know which position the teams will have for this match. So this is University of the Republic in Uruguay, who will be defending the position against the motion. So it means, as a consequence, the University of Applied Science team will be defending the position in favor and will be starting the match, because it is always the team who is in favor who starts the match. So concretely, it means that in the absence of international, so concretely I mean for the universities, they will defend the position in favor, which is, in the absence of international legislation on space resource extraction, customary international law should be guided by the national legal framework of states that have an established legal framework for such an activity. On the other side, the University of the Republic will defend the position that in the absence of international legislation of space resource extraction, customary international law should not be guided by the national legal framework of states that have an established legal framework for such an activity. So now you will see the timer So you will have 5 minutes, of course, for your for reviewing your notes, and of course we'll start with the position in favor. So it means the Hague University of Applied Science. So you may start already to close your microphone and camera, and I will start, of course, the timer. So, time is up for the preparation. You can, all of you, open the cameras. And we'll as well give the floor to one of the judges to introduce, of course, himself. So, Professor Larsen, welcome. So, thank you for joining.
Thank you.
Yes.
Yeah, I am associate professor in law at the University of the Faroe Islands. I have not been following this closely, but I didn't get the impression that this was the exam itself, rather than a preparatory meeting. But is this the exam itself?
Yes, yes, is the competition,
Okay.
let's say. Yes, the official
but
match.
I can follow it, and I can rate it later on, I think, on the template you have for
Yeah.
that, right?
Perfect, yes. Many thanks. So yes, we'll start the match now. So we'll give the floor to the Hague University of Applied Science for your introduction. You have 4 minutes.
Thank you very much. Esteemed judges, honorable opposition, and guests. Space resource extraction is the extraction of valuable resources from celestial bodies such as asteroids, comets, the moon, and Mars. Although full-scale resource extraction is not happening yet in space, last year NASA awarded contracts to 4 companies to extract small amounts of lunar regolith by 2024, effectively beginning the era of commercial space mining. My colleague Tolga Dogan and I, Simon Kochvold, will argue that in the absence of international legislation on space resource extraction, customary international law should be guided by the national legal framework of states that have an established legal framework for such an activity. We will elaborate our position by going into the following arguments. Firstly, relying on national law provides legal certainty. Secondly, national law ordinarily guides CIL, customary international law. And thirdly, national law should guide customary international law, especially when based on best practices. Coming to our first point, the absence of international legislation on space research extraction creates legal uncertainty. The Outer Space Treaty of 1967 forms the basis of international space law. However, it and other relevant international treaties do not concretely address the issue of space resource extraction nor space resources. It does lay out some important principles related to these types of activities. National law for space resource extraction, which complies with the Outer Space Treaty, should therefore guide customary international law on this issue to provide legal certainty for actors in the industry. If politically we can't agree through traditional fora such as the UN Committee on the Peaceful Uses of Outer Space, there is a need for custom to guide any such extraction in the future and provide legal certainty. This is the only way to address the problem proactively before extraction happens in space, instead of reactively after something has gone wrong with such an extraction. Secondly, coming towards customary international law is a general practice accepted as law. A custom can be established by first showing state practice, and secondly, opinio juris, meaning that the acceptance of this practice as law. State practice can be administered by acts, national legislation, and case law, according to the International Law Commission. Furthermore, the relevant practice does not have to be conducted vis-a-vis other states and can concern purely domestic practices. The International Law Commission also counts national legislation as possible evidence of opinio juris. So far, the US, Luxembourg, the United Arab Emirates, and Japan are the 4 countries that have laws regulating space resource extraction. Since we don't yet have any international legislation on space resource extraction and no states directly engaging with such activity, we must look to national legislation of the previous stated states to establish custom. Coming to our third point, states that have established legal frameworks for space research extractions that have been developed in consultation with international bodies such as the International Institute of Space Law and the UN Committee on the Peaceful Uses of Outer Space should provide guidance for customary international law. Relying on such national frameworks would help promote international best practices in this industry. Such practices can be found in the US Space Research Exploration and Utilization Act of 2015. The law recognizes the rights of US residents to own materials scattered in outer space, but does not claim US or private ownership of celestial bodies, as prohibited by the Outer Space Treaty. The Act also prohibits any states, any US space resource utilization missions from causing harmful interference with outer space. This is in line with the guidelines by the UN Committee regarding space debris, non-contamination, and sustainability of outer space activities. Thank you, and that concludes the opening statements.
Thank you very much. So now I give the floor to the University of the Republic of Uruguay. You have as well 4 minutes for your introduction.
Honorable panel and esteemed colleagues, there are many arguments to be against this statement. In the first place, the International Court of Justice defines customary international law as a general practice accepted as law through Article 38 of its own statute. In the North Sea case, a leading case regarding customary international law, the sentence says that the acts made by countries not only need to be a settled practice, but also that they must be carried out in a way that they reflect the belief that they are done because they are compulsory. These two elements helps us to distinguish two elements of customary law: the psychological element, otherwise referred as the opinion juris, and the material element. It is completely inaccurate to state that we are in presence of a general practice when only 4 countries have legislated on space resource extraction. Also, the UN Law Commission draft in the conclusions on identification of customary law says that legislation itself, national legislation, is not sufficient enough to prove the opinion juris. This is because legislations are a direct consequence of political choices, which brings us to our second point: the undeniable relationship between space law and politics. Despite the fact that the Outer Space Treaty is based in principles such as the non-appropriation, freedom of navigation, and solidarity among states, the international community must never forget the events that inspired the creation of this treaty, that were caused by the rivalry between the Soviet Union and United States and the deep context of uncertainty that this created. And this is why we must pay a special attention when we talk about these legislations, because space is a symbol of power. Space represents the unreachable. And even the doctrine has said that space resource extraction could be resembled as a second space career. So we must pay special attention, especially when these new legislations are separating from the founding principles of space law, such as the non-appropriation. The example of that my colleague said about the United States, the Space Launch Act, is a clear case that shows how Article 6 and Article 2 of Outer Space Treaty could be manipulated, ignoring the spirit of the law that intended to forbid the appropriation of resources, and to start encouraging other countries to adopt similar legislations when the US is allowing citizens and industries to exploit space resources. And this will create tension between countries because they will follow these kind of legislations, arguing that if they do not do so, they will fall into economic disadvantage between countries that start doing so. So this must be seen, this approach must be seen with a critical view in order to protect not only humankind, but also the international community as a whole. Also, my partner will later on elaborate on the Luxembourg case, a case that shows us how people and citizens know about, governments know about the international treaty and its provisions, but are deciding to ignoring them. Thank you very much.
Thank you very much. So now we start the round of the rebuttals. So we'll give the floor to the University of Applied Science for the first rebuttal they have. You have 2 minutes.
Yes, thank you very much. Ladies and gentlemen, the opposition has raised some very interesting points regarding international customary law. While it is true that customary law requires state practice and superior juris, it is important not to forget the draft comments by the ILC, the International Law Commission. Those clearly stipulate that unilateral national acts, including laws and statements by governments, in fact points towards the existence of opinion juris. Secondly, it is very important to bear in mind that customary international law must not always be universal, but can also be limited to a certain region or group of states. This principle is reflected in the so-called principle of particular customary international law, pointed out by Conclusion 16 of the International Law Commission. This rule of customary international law only binds a specific group of states that is engaging in a certain act under the belief that this act is binding, therefore your opinion to this would be present. This could apply, for example, to states like the United States, the UAE, Japan, and Luxembourg who have enacted such legislation. Secondly, regarding the non-appropriation principle, this has also been reflected in the United Nations Convention on the Law of the Seas, which similarly requires non-appropriation. However, it is important to bear in mind that non-appropriation simply means that states may not claim sovereignty over territories within the sea, and similarly over outer space. However, non-appropriation does not preclude the appropriation or, the extraction of resources. Therefore, within compliance of the non-appropriation principle, states may still extract space resources guided by national law that could form opinion juris, therefore form customary international law, without violating any principles of the Outer Space Treaty of the Moon Treaty. Thank you very much. We will now yield the floor back to the opposition.
Thank you very much. So now I give the floor as well for the first rebuttal to the University of the Republic in Uruguay. You have 2 minutes.
Well, thank you. Well, we agree on what your team said on the considerations that the UN draft on international customary law. But we cannot forget that these 4 countries that have legislated on this subject are signatories of our space treaty. This treaty determines the regime of human activity in outer space. Through Articles 1 and 2 establishes 2 crucial principles. First one, exploration and use should be carried in benefit of all countries and humankind. And second principle, outer space is not subject of appropriation. So not only there is legislation on the subject, but also there is a prohibition, which in fact is recognized by countries who have national laws on this matter, explicitly or explicitly. And this is the case exactly what happened in the lawmaking process in Luxembourg. Basically, there in Luxembourg, the consul that alerted the Chamber of Deputies that this is the disposal that established that resources in space could be appropriated in accordance with international law was a controversial article. So as a result of that reference, of that warning of the consul to the Chamber of Deputies, the Chamber of Deputies responded by removing the reference to international law. So actually, if we go to the reading of Article 1 of that law, we now simply read, because it simply says, space resources are capable of being owned, without any reference to international law. So this demonstrates 3 things. In first place, there is no absence of international legislation on the subject. Secondly, they knew it perfectly at the time, and that's why they were in breach of international law by violating Article 2 of our space treaty, of which Luxembourg is a signatory state. So, in conclusion, it is illogical and incoherent to say that international customs should be guided by national legislation when these countries by themselves expressly recognize that there is no customary international law on the matter. Thank you.
Many thanks. So now we move to the second round of rebuttals. So I give the floor to the Hague University of Applied Science. You have 2 minutes.
Thank you. And you're raising some interesting points. However, even though it's not explicitly stated that the law can constitute customary international law, a national law can still be a guide for customary international law. Many national laws, such as the US law, can comply with the Outer Space Treaty, specifically Article 1, which states that the exploration and use of outer space shall be carried out for the benefit and the interest of all countries, and that outer space shall be free for exploration and use by all states. The extraction of rare earth metals necessary for the shift to renewables from deep space mining should be in the interest of all countries and could benefit everyone in accordance with Article 1. The right of all states to use and explore space also indicates that this type of activity should be permitted. Lastly, Article 2 prohibits national appropriation of outer space, but most analysts agree that this article refers only to outer space as a whole and not to its natural resources. Space is already being heavily exploited because space resources include non-material assets such as orbital location and abundant sunlight that enables satellites to provide services to Earth. So this is not something new in that regard. And we can also look that there's not only these 4 states that have national legislation, but we can also see that there is a multilateral attempt in the Artemis Accords, which is, although it's non-binding, it's a multilateral arrangement between the United States government and other world governments. It's with 23 signatories, including many spacefaring nations. That includes that such utilization of space resources can benefit humankind, and it does not, and it does comply with the Outer Space Treaty Article 2. So this shows that there is a wider acceptance for space resource extraction. Now we yield back the floor to the opposition.
Thank you. Thank you very much. So now I give the floor as well to the University of the Republic for a second rebuttal. You have 2 minutes.
The issue at hand presents a lot of interrogations, and one that we have reflected is how can private companies reflect and adopt the benefit from humankind? Because private companies will serve to their own interests and will respond to them. So how are governments going to control the situations? And also, by habilitating countries to go against their obligation and go against the principle of Pact of Ut Servanda, how will this repercute in the international relationships as a whole, in the international community as a whole? There is no doubt that the space issue and how the human being has responded to this reality is completely meaningful for the evolution of humankind. However, how we as a global community decide to approach will directly impact on the future, on our future. And this is why we should work together rather than alone or by individual interest. There is no doubt that a lot of inequities will surge from these legislations, because countries who have the capacity of implementing this kind of legislations, of investing in this kind of resource exploitation, will benefit from this. However, the countries that are not developed technologically now, or that have other social needs to take care of, will be excluded of this process, and the international community will be affected as a whole. Thank you very much.
Thank you. Thank you very much. So now we move to the conclusions. So we hear first the conclusion from the University of Applied Science. You have 2 minutes.
Yes. Thank you very much. Esteemed judges and opposition, in the words of the late astronomer Carl Sagan, we have lingered enough on the shores of the cosmic ocean. We are ready, at last, to set for the stars. However, the present absence of international legislation on space resource extraction leaves us in a legal vacuum. We are missing our sails in the context of this quote, and the wind is picking up. The national legislation enacted especially by spacefaring nations such as the USA, Luxembourg, and Japan on space resource extraction can provide and must provide useful guidance for the formation of customary international law on this issue, especially when guided by the principles established by the Outer Space Treaty of Non-Appropriation and the United Nations Committee on the Peaceful Uses of Outer Space. This can help to promote greater consistency with respect to space resource extraction. Legislation while also helping to avoid potential conflicts and legal uncertainties that might arise in the absence of such legal guidance. Of course, the guidance provided by national legal frameworks should not be determinative by itself. These are only our metaphorical training wheels in our explanation of our exploration of the cosmic ocean. Ultimately, the international community can remove these training wheels by creating a binding international treaty comprehensively regulating space resource extraction for the future. Until this is not the case, however, we rely on national legislation that forms state practice and may do so by unilateral legislative acts as confirmed by the ILC to form international customary law to address this regulatory gap. We thank you very much for your attention, and we now yield the floor for a final time to the honorable opposition.
Thank you very much. So now, I give the floor as well to the University of the Republic for your conclusion. You have 2 minutes.
Well, thank you. Well, customary international law should not be guided by national legal frameworks on behalf of mainly 3 arguments. In first place, only 4 countries have legislated on space resource extraction, so only 4. Can we talk about international customary law when only 4 countries worldwide have gone through that process? it is obvious that we cannot, and not only the UN International Law Commission holds this position, but also the International Court of Justice through its jurisprudence from more than a half century. In second place, not only there is legislation on sports resource extraction, but also there is a provision, as I pointed out in my previous intervention. So the case of Luxembourg, which was previously developed, depicts the hypocrisy of countries that have national laws on the subject, together with the Japanese case, which I forgot to mention in my past intervention. But basically what happened in Japan is that the Japanese government, although being an outer space treaty signatory, conceded a license to iSpace, which is a private company, for the use of the moon for resource extraction. In third place, humanity still savours the aftermath of the Cold War and the competitive veil that clothes our space. So surely, if I ask each one of you who Neil Armstrong was, everyone may know it, the first human to get to the moon. It is not a mere coincidence that everyone in this debate, although not being born at the time, had the vivid image of Neil Armstrong nailing United States flag on the moon surface. So, and that's why there is a political background which underlies this matter, which cannot be underestimated. So we are witnessing a second space race with everything it implies. Humanity must avoid most powerful countries to be judged on party, so national legal frameworks cannot be the reference at all on this subject. So on the view of this argument, it is clear that customary international law should not be guided by national legal frameworks of countries who have legislated on this matter. Thank you very much.
Many thanks. Many thanks. So we heard the two conclusions. So it means from now you are not under evaluation anymore. So it means you can brief, and of course we'll be debriefing as well a bit this match with you, and as well with the judge present in this room afterwards to give some maybe impression already or feedback on your performance. So I will start first asking each of you, the students, what you have done, what you think about this topic, in general how you prepared it, if it was part of your studies in general at some point at this moment, or not at all, or if you discovered maybe everything during this preparation of the 7 days. So I will start with Mr. Dogan. So what did you think about this topic? How did you prepare? Was it connected to your studies?
Yes, so when I first read the prompt, I was kind of intimidated, I have to say, because my knowledge on space was very limited at the beginning. I did not have it in my studies yet. And I also think, unfortunately, there is not yet such a module in our curriculum, at least. So there was a lot of self-teaching. And I found myself personally also siding with the pro side in the argumentation. I think if you follow their train of thought, or if you follow the con side train of argumentation, you could easily slip into this kind of colonial annexation of space almost, which I found hard to defend in the past hour. But I think, yeah, I've learned a lot personally, and I'm excited to see how the state of art is developing with respect to space resource extraction, because as we've seen, NASA is selling licenses, Japan is selling licenses, so yeah, the commercialization of space is happening, and I'm excited to see where it goes.
Okay, thank you very much. Mr. Michelini, what do you think about the topic, the performance of your team, the other team, and how did you prepare the match? Was it connected maybe to your studies?
Well, while listening to Dogan, the colleague of the Hague, I felt extremely identified because although here in Uruguay we have some people that has gone to NASA and is studying the space matters, not linked with law, but with space at the end. Here in law school, we are pretty far away from what the space world is. So it was extremely interesting to discover this new scenario of law, because I discovered some regulations, some actual current political and economical situations, that as the Japan license, which I got extremely surprised with that. I got pretty shocked by that. So it has been extremely enjoyable task to investigate on this subject. So I thank the COAS Foundation for proposing this topic.
Thank you very much. Mr. Cockwall, what did you think about this topic? How did you prepare it? yeah, the other computer. Then. Yeah.
Wait, let me turn off my microphone.
Yeah, we can hear you. Yeah.
I found it okay to research. We also got a bit of help from some of our lecturers who had some knowledge about space law. And no, I found it a really interesting topic because first I was unsure whether it was like about space mining or whether it was more about customary international law. But I found like this was a cool overlap between the two because essentially you have to argue both of these aspects. And yeah, I felt like it was a very teachable moment, or like I learned a lot about space law in general.
Thank you very much. Miss Maria Federica Sanz?
I think that something wonderful that happens in this debate is that you receive an email with a topic and you don't know, most of the times you don't know where to start, and then you end up studying and internalizing a lot of historical facts, legislative facts that you wouldn't study if it wasn't for this debate. And we would like to say with my partner that we are so grateful for being part of this platform, because it has been extremely meaningful for us. We are so happy of meeting these new colleagues and people who love law, because
Yes.
we feel passion for the things that we study. And we would like to thank also Alejandro Pastori, our professor, and all of our mates here in the Republic University.
Thank you. Many thanks. Now I give the floor to one of the judges within the room, Professor Larsen. So what did you think about this match, and as well maybe the knowledge that they were using and the arguments as well?
Yeah, I'm of course not going to give my judgment. That's going to be for private reflection and the template that you have given me. But you students come across as very well-spoken and very thoughtful in this topic that is very, what should you say, it's a very theoretical topic, and it goes at the core of the purpose of law and the purpose especially of international law. And without a good take on that topic, you're not able to speak as well as you did. But I'm not going to give any indication here about which preferences I have for giving points. But of course, I'm impressed with your presentations, so I'm looking forward to this grading.
Many thanks indeed. You will have time indeed to maybe rewatch the match on YouTube or check indeed what maybe.
Yeah, I will rewatch it on YouTube because I get a link from YouTube, right?
Yeah. Yes.
And I will study it more closely. I'm not an expert on international law, but I am done a lot of teaching and some writing on jurisprudence. So matters of a deep theoretical nature are close to my interest. So I think this is very exciting for that.
Many thanks, and as we discussed by email in the past, maybe these students will inspire maybe your own students in Faroe Islands, maybe for next year, to try.
What I like about this is that you urge very young students to think very hard about a very basic problem, and I think that's a really good way of cultivating the legal instinct, intellect. I mean, from early on. So I like this setup.
Yes, many thanks. So thanks as well for connecting today. So what will happen during the next days, obviously, is that the three judges will be filling the forms, evaluating both teams. So it means as well the judge who is in Armenia, the judge who is in Zambia. So they'll be watching the match when they have time, tonight or tomorrow, and we'll add up the scores, and the team who get the highest cumulative scores will get to the quarterfinals, and that team will be facing the universities. The winner of the other match of yesterday between the University of Manchester and the Catholic University of Lille. So that was yesterday's match. So that winner will face the winner of this match. And of course, we want to add as well that if some of you would like to come to The Hague for the final week in the end of May for the finals, it means with the best teams competing, I mean, from this competition, you are welcome, because we'll have some visits of international organizations like the Peace Palace, like the OPCW, and Eurojust, Europol. So yes, it's in your way. Of course, you can see if you can make it. I know that one of you in the room, I will not tell who, contacted us because this is maybe a possibility to come. So indeed, you are all welcome. And of course, yes, you will meet other teams in person, some judge potentially, during that week at the end of May. So now, traditionally, we'll close this session by a bit of networking and connections between the different countries present in the room. So we'll ask Mr. Dogan, have you been in Uruguay or in Faroe Islands?
No, unfortunately, I have not. But I have to say, South America in general is very much on my bucket list, especially considering that I now live in the Netherlands. The weather is, there's a lot to wish for in terms of Dutch weather. So I hope closer to the equator, it gets better. But yeah, no, I'm definitely planning on seeing more of the world, and also maybe definitely visiting Montevideo, because a lot of international, or especially the Montevideo Convention, as a special interest as a law student. Therefore, I'm very much looking forward to seeing other parts of the world.
Thank you very much.
Indulge in a discussion on the state concept of state, Montevideo. Yeah.
So yes, I mean, this is indeed a good way to learn as well international law, to visit the place where it got signed, some as well treaties. Mr. Michelini, have you been to the Netherlands or in Faroe Islands?
No, I've not been in either of both countries, but totally, if you hope to find yourself in a more amicable weather, I recommend you to come in January or February, not in June or July, because you are going to be disappointed. It's getting cold here right now. But I would like to visit Netherlands, and I, in fact, email the Cox Foundation, because maybe it's a possibility that I will confirm in these days that I'll be traveling for the final week. So I'm pretty excited to get it and know you in person. So thank you.
Yes, so indeed, you emailed us and you are welcome indeed if you want to come. Mr. Cockfall, have you been in Uruguay or in Faroe Islands?
So no, I have not. I mean, I'm from Norway, so Faroe Islands wouldn't be too far away. And I noticed, like, from your name, I thought, like, yeah, I could recognize that it's a lot of similarities between our languages and people. But in terms of Uruguay, I have been to South America before, and specifically in Colombia, so it's a bit further away. But I would be delighted to come visit. And actually next year I was accepted for exchange to Brazil, so for next semester. So actually it would be maybe likely that I would try to have some time, maybe after like as you said, to maybe go in December or January, because I think our semester ends mid-December and we don't start here again until February. So I have some time. And it would be really cool to explore more of South America, and definitely Montevideo, and then yeah, it would be really cool to visit you, and also to maybe see Buenos Aires as well. So yeah, I'm hoping to get to see this.
So thank you. Yes, of course, we can help you to exchange, I would say, the details, the contact details, to meet and to visit each other. Finally, Miss Maria Federica Sanz, have you been to the Netherlands or in Faroe Islands?
No, I have never been to Europe, but someday I hope to meet Netherlands because of its cultural and historical value. I think that it's a country that you should visit at least once in your life. And if things go okay, I might join my partner, Nacho. So we'll see.
Great. Okay, so you are both welcome, of course, to visit the Netherlands maybe in a few weeks from now. and to meet the other team as well. Professor Larsen, have you been to the Netherlands or in Uruguay?
No, I have not been. I have been in Brussels, close to the Netherlands, but not in the Netherlands itself, unfortunately. And I've never been to South America, but I've been to North America. I've been to the US twice. So, but I'm very fascinated by Latin America, so I would like to get there.
Okay.
I have been in Norway though, but you didn't ask about Norway.
Yeah,
but
yeah.
that's very close to us, so we feel a bit.
Yeah,
We are kind of old Norwegians.
actually, tomorrow I will be in Norway because I have to for a professional trip, so I will be in Oslo just for 24 hours. I've been about 20 years ago when I was a student in Sweden. But yes, and concerning, of course, Netherlands, we'll be very happy as well to invite you to see if there could be some connection between the Hague and as well your university in Faroe Islands. So I was planning to go to Faroe Islands last year, but yeah, I had some...
Of course, you should also be very welcome to come here. We have a very young university and a young law faculty, so we're just starting off. We launched our full law program from 2019. So we are a young institution.
Okay.
We try to do it in a methodologically rigorous way because we think that we are a very small society with a scarcity of legal sources and resources. So independent thinking is important for us. So that's why I really like a topical issue like this.
Okay. So, of course, yeah, we keep contact to make sure that indeed we can visit each other. Many thanks also for accepting to judge another match, a second match, a bit later, maybe a quarter or semi-finals. But yes, many thanks again for joining for this match, and of course the teams will welcome your evaluation during the next days. So
yes.
Merci.
I look forward to this, and have a nice day, everybody.
Thank you very much.
Bye.
Thank you in the Netherlands. Thank you in Uruguay. Thank you. Bye-bye.
Thank you.
Bye. Bye.